we'll get this underway. I'm Lisa Jackson, the Foundation Director at Jamestown Regional Medical Center, and I have been blessed and working in healthcare now for 7.5 years at JRMC, and I welcome you to our webinar today, our Zoom meeting. We're feeling very fortunate to be here, even if it's over the internet, with Doug Olson with Thompson and Associates. And before we get rolling into his slides and a little introduction for him, we wanted to express our gratitude here at JRMC during this challenging time. Support for both our staff members as well as our patients. Despite the certainty surrounding all of our lives, people are stepping up to help others, and it just makes these acts of generosity even better. So, and even more meaningful. As we all know, the COVID-19 pandemic presents unprecedented health challenges for everyone. And in this time of crisis, it has been really natural for families to take a step back and think about their legacy and their loved ones' security right now. According to CNBC, as well as the Wall Street Journal, and even Google itself, there has been a tremendous increase on information as far as a search for insurance, wills, estate planning. But as we all know, the internet or Google isn't probably the best place to find this information, just because it can't be customized to your situation, your family, your needs, your legacy, and your values. And so with an overload of all this information here at JRMC, we tapped in some of our amazing resources. JRMC has been working with Thompson and Associates, specifically Doug Olson, for 2 years now. He works with our supporters and our staff on estate planning education and planning. And today we wanted to offer a free Zoom to talk about some of the most current changes in tax law, what to do for some basic planning, and then what we offer here at JRMC for those that are interested. And so with that, a couple housekeeping notes, and then I'll turn it over to Doug. But you'll see in the bottom of your computer, there's a place for you to leave your comments and questions as we move along. So you just type those in there, and at the end of the presentation, we'll address them. If we run out of time, we will follow up. We have your contact information, hopefully. If not, please include it in a private message to either me or Doug, and we'll follow up with your specific question. And then also, just make sure you're muted, and that works really well for these types of meetings. And if you want to have a full screen of Doug and his presentation, you go up and there's a little blue box in the corner of your screen, and that'll allow you to pin Doug, and he will become your full screen. I'll fade away so you can see the slides that he's showing today. And then, of course, if you have any questions, you can always follow up with me in the foundation office with Penny Holland at 952-4880 or through our emails, foundation@jrmc.com. So thank you for being here, and I hope you have an enjoyable rest of the week. And I'll turn it over to Doug, who can explain more about what he does and is very much, in 14 years of practice, credentialed in this type of advising as a CFRE and a FCEP, and Senior Vice President and Regional Manager at Thompson and Associates. Okay. So Doug, take it away. Thank you very much.
Okay. Hey, thank you, Lisa. And good morning. Hello, everyone from Omaha. I'm joining you today from Omaha through the wonders of technology. So I would imagine I'm saying hello, North Dakota, to most everyone who's joining us on the presentation today. Thanks for joining us. Yes, I've been with Thompson Associates now for 14 years. Prior to that, I worked with numerous not-for-profit organizations doing some estate planning, some plan giving, some regular fundraising for those organizations. Prior to that, if you want to go way back 30 years now ago, I completed a 6-year time during which I was a pastor in Lutheran congregations. So I have a background that has given me many opportunities to work with nonprofits and individuals, especially individuals on a very personal basis. And that's what we like to do and hope to do to be of help to you in your planning. Lisa and I, yes, had been talking about how we could help people, with some important things at a time like this when we can't yet gather back together again. And so we decided, well, I guess we could try to Zoom. And so here we go again with the Zoom. I don't know how many Zoom presentations you've been a part of, but actually they are a great way to connect. And I know this Zoom meeting is being recorded as well for review in the future if you want to do that. So thanks again for Zooming with us today. Let me start sharing my screen here, my presentation today. And just a second, I'll get it all queued up. There we go. There we go. I hope everyone can see that. We're going to talk about basic planning today for life stages. Cover a lot of grounds, focusing specifically on some things we need to be thinking about, brought about by the coronavirus challenges. But then beyond that, the big picture questions of life, our basic planning as we move along through our lifetimes. Before I begin, I suppose I should just offer this legal notice that, of course, my work with Jamestown Regional Medical Center, my work with all of my clients, and the general position of Thompson and Associates is that we are not involved in providing official legal accounting or tax advice. So let's just have that be clear right off the bat. We have some ideas to share. There's some things that we're very happy to help educate people about. But we understand and encourage everyone to work with your own legal counsel, your own accounting people as you move ahead with any of these ideas. So just want to start there. Well, of course, the elephant in the room, in fact, the elephant in the world here for the last number of months, probably 6 to 7 months now, has been this coronavirus. And it has changed so many different things, so many things, as we all know. One thing that has been on the kind of had a major upswing in these last months has been a tremendous increase in interest in wills. And you can see this this statistic here, and I think Lisa also alluded to this in her preliminary remarks. There's been like a 70% jump in demand for wills even in March of this year. And on the other end of things, in terms of financial planning, life insurance agents have reported a big spike in new business as well. I think that's because people are uncertain, and I think people, especially in the early going, maybe, were scared by the virus. Now we've learned how we can kind of work with it, deal with it, respect it, and be as safe as possible. But the coronavirus has changed a lot of things. Here's a graphic that I think is interesting. If we were together in person, I probably wouldn't have you raise your hand to ask if you have a will. I think sometimes people are surprised to learn how many people do not have wills. Especially people who don't have wills themselves. They kind of assume everybody else does. There are a lot of people who do not have a will. And this says maybe 50% do not have wills, 50% do. I'm not sure if that's the right number or not. I've been saying for several years now, 60% of the population is without a will. And the 40% who do have wills, in many cases, probably 70% of those people, the issue is that their will has now become out of date because things change. And that's one of the themes of our presentation today. Things change, life stages require different responses. And so we want to keep that in mind as you think today with me about your will, your planning, and what changes may have happened in your family that you might want to address. I want to talk to you real quickly about the CARES Act. One aspect of our national response to the virus has been this legislation known as the CARES Act that was passed this past spring. It stands for the Coronavirus Aid, Relief, and Economic Security Act. It's a very broad piece of legislation that was providing support for businesses and taxpayers and charities, for individuals as well. I'm sure you've heard some things about it. We're going to talk in a little bit about some of the specific provisions of the CARES Act. First of all, let's talk a little bit more about planning. In the face of these new challenges, but I think also in the face of regular challenges, the regular course of life, it is important that we plan effectively. Two things. We need to plan. Some people don't plan, and that's problematic. But when we plan, we also need to plan effectively. So what are some of the elements of effective plans? Well, number one might be assessing the situation correctly. That is so important, isn't it? Getting started in the right way. There's that simple illustration that I've heard of for years that when it comes to buttoning a shirt, the most important thing is that you get the first button correctly, and then the others will kind of come into line. But it is important always, as we do some planning, assess our situation appropriately and move forward from that. Clearly identified objectives is obviously an important part of planning. Not only what's the situation, but okay, what's what is important to us? What is important to us? Sometimes that involves balancing personal issues. I mean, to lean in the direction of one personal issue may negate or diminish the importance of another personal issue. So it's kind of keeping things in balance, selecting the proper techniques. And there are a range of techniques, many techniques that most of us may not be aware of. And then, of course, having an understanding, if we're going to use some of these techniques, what do those tools, what do they do? Understanding the tools that we use. It's really kind of like juggling, you know, it is kind of juggling. Proper planning is not a simple thing because we're trying to keep several things in balance. Taxes is a big issue when it comes to planning. And when it comes to taxes, of course, there are various kinds of taxes that we need to keep in mind. The one that we all deal with all the time, every year, is income tax on our income. Some people deal with capital gains tax on appreciated investments, appreciated assets. Gift tax is an issue for people who might want to pass on a large gift to other persons. There are limitations on the size of gifts we can pass to people. Generation skipping taxes, if we're talking about an estate situation, if we bypass our children to pass assets directly to our grandchildren, there may be generation skipping issues. Inheritance tax, a lot of times people just think of any taxes in the estate as inheritance taxes, but there are some states that have specific inheritance taxes where it is the inheritor who is taxed on what they receive, not just the size of the estate being passed on. And then, of course, estate taxes. There is a federal estate tax, and we're going to focus on that a bit today. In our Thompson planning process that we bring to JRMC, we talk with people thoroughly about federal estate tax, how it is determined, whether it's an issue for you and your family or not. In terms of, yes?
Sorry to interrupt. This is Lisa. I don't know if anyone else is seeing the screen the same way, but the slides aren't changing.
They're not?
No, they're not. So if they're changing in front of you, will you just switch the pull up what's in front of you.
Okay.
Are they changing in front of you and not us?
Yeah, they're changing for me. I'm sorry, folks.
No,
I didn't know. Thank you,
that's
Lisa.
okay. I
I
knew
had no idea. Yeah, this was working.
it's frozen on my screen. It is not from the beginning, and so
Okay.
if you're
Okay, let me stop this sharing. Okay. And let me try to reshare. I'm so sorry. I'm glad you stopped me. Let's go back and see if we can do this again.
and if it doesn't pop up on the appropriate slide, I can. There you go. Perfect. It was
Okay.
just it was just frozen.
I
You're
guess
good.
so.
Thank you.
Okay. You know, technology is a wonderful thing, isn't it? Okay, this is what I was talking about in terms of planning being like a juggling act. So estate tax, I guess the point I was going to make is from state to state, some states have estate taxes. Of course, North Dakota does not any longer have a state estate tax. Your neighbors to the east over in Minnesota have a state estate tax, and honestly, one of the higher taxes in the country when it comes to passing on assets from the state. Other things in the planning include family dynamics, personal goals, and probate laws. So we're going to talk about some of these things. Okay, tell me now. Well, let me see here. Now okay, did that screen change? Lisa?
Yep,
Good.
you are good to go.
Okay, good. Want to make sure. Okay, so we're talking about planning for different stages of life. The thing is, estate planning needs change as we move from one life stage to another. A will, for example, that was good when it was our primary interest was guardianship as the main issue, doesn't have the same effectiveness once maybe we're in our 50s or 60s and the kids are out of the house and on their own. So here you can see some different stages of life and calling for different goals. Please notice that from the 20s on, basic estate planning, having a will is an important thing. I think what changes is the needs and the focus of the will as we move forward. But even people in their 20s should be thinking about basic estate planning, at least for guardianship issues, and then maybe have some life insurance, disability insurance in case something would happen, to provide for a surviving spouse and the kids. In the 30s and 40s, people begin to build retirement accounts and other savings. In the 60s, keep updating those wills, perhaps add trust depending upon the size of the estate or the complexity of the estate. Consider long-term care issues. If you're interested in putting in place a long-term care policy, it's less expensive if you start earlier. And then in the 60s, more advanced estate planning, you're also beginning to move into maybe business succession issues at that time, long-term care, pre-to-retirement planning, and then post-60s, post-retirement, in retirement, updating and monitoring the estate plan. An estate plan is always a dynamic, changing document, and I want you to, of course, keep that in mind and stay on top of it. So what's an estate? Let's talk about that a little bit. Sometimes I work with people who say, we're not rich, we don't have an estate. Well, what is an estate? An estate is really simply what we own. Whatever we own, that's our estate. And it can involve these things: home, business, other real estate, farm, bank accounts, investments, personal effects, or things like retirement accounts, the IRAs, 401ks, 403bs, 457s, life insurance. An estate can be all of these. In fact, an estate is all of these things. So let's talk about good planning. Good planning, again, starts with setting clear goals. And goals are usually based in our values. So our values are what? Our values are what's important to us. Where do we want to go? What do we want for our family? What do we value? So for example, have you and your kids ever really talked about what is most important to you as a family and how that might continue over time? If you're a farm family, for example, what are your goals as a family for the farm? Do you want it to stay in the farm, stay in the family? Who is interested in the farm or living on it or continuing to operate the farm? And then how do you want that farm to be transitioned, passed on to another family member? And how do you do that in a way that is fair and as equitable as possible to all the members of the family? I know as a farm kid myself how important issues like this are, but those are good examples, I think, of planning values, planning goals, setting clear goals. Here's some common planning goals for people. These are kind of general, accumulating assets, building an estate. Our goal in life is not to live from paycheck to paycheck or month to month, but hopefully to accumulate some assets, to build some securities, to build some wealth, improve our standard of living and maintain it in retirement years, provide for care. What if we're disabled? We want to provide in case of that situation, provide certainly for a surviving spouse, and then ultimately provide for the transfer of assets to family and other beneficiaries. In my mind, it kind of comes down to simple words like accumulation, security, enough to live on, and then ultimate distribution of assets. So let's kind of look here at some of the unique issues here in 2020, some new considerations. Some of these started moving in place even before we got into 2020. The Secure Act is a piece of legislation, a piece of legislation that was approved last December of 2019. And what I think everyone needs to know about that is it moved for people who have retirement accounts, it moved back the required minimum distribution age from 70.5 to age 72. For years and years, we've heard about the RMD being required at age 70.5. Now that is age 72 moving forward. That's a permanent law as far as we know. The other thing about the Secure Act is it has an impact on inherited retirement accounts. What it did was to limit the stretch, as we call it, the period of time over which heirs might take distributions from those retirement accounts. For years, I've been talking with my planning clients about their heirs having the option, the choice, to perhaps take any inherited retirement accounts over their whole life expectancy, meaning a long-term cash flow opportunity. Well, with this congressional act, they shortened that to a 10-year term. So now if heirs inherit retirement accounts, they have to have all of the retirement assets out of the account within a 10-year period. They get a little more per year, but it certainly does also increase their taxes. Of course, the related issue to this is that if heirs are inheriting retirement accounts, the biggest tax trap in all of estate planning is if heirs choose to take the full lump sum of assets, because that would make all of those assets taxable in that year, and they would be stacked on top of other income that those heirs would have. So who knows what their tax bracket might be. In many cases, it moves to the top 37% tax bracket federally, plus any state income tax. So that's the Secure Act. Let's move to the CARES Act, and I mentioned this earlier. This is the act passed this spring to provide some relief, temporary relief, in the light of the coronavirus. Related to required minimum distributions, the CARES Act has said for those people who don't need to take distributions from their retirement accounts this year for living purposes, there's a waiver. There is no required minimum distribution this year. If you're in that situation, be aware of that. You don't have to take anything out and thereby increase your income this year under the CARES Act. In terms of charitable opportunities, many of you are aware that under the law passed at the end of 2017, the standard deduction had moved from like $6,350 per person to above $12,000 per person, double that for couples. And so moving the line in terms, if you itemize charitable deductions, it took a lot more charitable deduction to get any benefit in terms of a charitable deduction. This year, under the CARES Act, there's an above the line charitable deduction of donations of up to $300 for an individual, $600 for a joint return without itemizing. So that's a nice thing for those who want to itemize. For itemizers, on the right-hand column there, this is a year where there would be a tremendous opportunity to make a larger charitable gift if you'd be interested, because the deduction cap has been moved from 60% of your adjusted gross income to 100% of your adjusted gross income for the year. That's not for everyone, of course, but in certain cases, it's a great year to consider making a larger gift if that's something you'd like to do. And likewise for businesses, they've raised the cap on charitable deduction this year from 10% to 25% of taxable income. Again, as with all of this, I would encourage you to talk with your accountant or attorney if this is an opportunity that you might want to explore. Okay, let's just talk in general, real quickly here, about planning your estate. I really like this quote, and so I'm going to bear with me, but I'm going to read it all. This is what planning estate is about. Planning your estate is a selfless act that is focused on the well-being of the people you will leave behind. Think of that. That's important. A thoughtful estate plan aims to provide for each loved one in a tailored way, preserve family harmony, very important, reduce unnecessary taxes, care for minor beneficiaries and those with special needs, and protect assets from divorce, creditors, and litigation. A values-based plan reflects all that is important to you, your family, and even beyond your family. Planning an estate is a very, it's an act of freedom, an act of vision. It's one of the most important things we can do. So let's talk about that a little bit. First of all, I guess, without proper planning. The problem with not having proper planning in place, of course, is that we kind of cede away our decisions to others. Someone else, for example, could choose who would be the caretakers for your children. Or if your children don't have a will, their children, your grandchildren. Or someone else chooses the distribution of your assets. Without proper planning, some of the assets that you may need in the future could be lost or depleted. You or your family may need, could be lost or depleted. Life brings some challenges. It brings challenges of poor health and long-term care. Without proper planning, we may not address those challenges appropriately. Probate is an issue. We're going to talk about that in a moment. It can threaten your goals. Taxes, and certainly mismanagement of your estate and mismanagement of your assets. These are all some threats that with proper planning, we can work through. We can get around these. We can avoid some of these problems. So let's just talk kind of from ground up about the primary issues that we see as important in planning. And I would begin with this. I would begin with what we call a medical power of attorney. That's one thing, and a living will, which is something a little bit different. A medical power of attorney is something that any of us may need during life should we become incapacitated, even temporarily. What a medical power of attorney does is allows a designated person to make some medical decisions on our behalf if we cannot. So we would designate that person ahead of time. That person may be called an agent or sometimes an attorney in fact, but it's to pick out a person we trust implicitly to make medical decisions for us. Let's say if we're in an accident or injured and we can't at that time make those decisions, but someone can make the decisions to help us be treated appropriately so we get well again. It can cover emergency decisions, non-emergency decisions. It can be immediate so that that agent has immediate power to make decisions, or it can spring into effect only based upon certain contingencies coming about. That's a medical power of attorney. Now, that's not to be confused with something we call living wills. Living wills is a different focus. It has an end of life focus in my mind. It directs the level of life-sustaining procedures that we would want to be used. Let's say if we were on being sustained only by medical equipment. This is really what you kind of call the when to pull the plug question. And it's important, it's to our heirs to take some of that pressure off them by making our wishes known. And really that is the upside. I suppose if there's a downside, it could maybe limit some of the choices available for treatment at that time. So you need to think it through. But a living will is something oftentimes that is a subset of a medical power of attorney. Sometimes they stand alone. They're also known as directives, but they're two different things. Medical power of attorney, temporary incapacity where we hope to be better. Living wills is more towards the end of life. Here's how they work together. Yes, again, healthcare power of attorney, that's really kind of ordinary life decisions. The living will, we choose ahead of time, and it has to do with life and death decisions. Moving up the foundation, property power of attorney. Again, just like the medical power of attorney, long before, or hopefully long before, we might ever need a will. If we are incapacitated, we may need someone to take over and make some property or financial decisions for us. That's what this person does. Allows the designating person to make financial decisions like pay the bills, make deposits, mortgage, sometimes sell assets. Again, this can be immediately in effect or springing into effect based on certain predetermined contingencies. But these are both very important for a good plan. Moving up, here's where most people think the planning begins, and that's with our last will and testament. I add to that beneficiary designations because the will does not by any means control all of our assets. In fact, let's talk about beneficiary designations real briefly. If we have retirement accounts, those are controlled not at all by the will, but by beneficiary designation documents. We list those, a primary beneficiary, contingent beneficiaries, and then we sign the document. That becomes its own legal document and creates a legal path that directs to whom we want to share those assets should something happen to us. Same is true with life insurance. They transfer not through the will, but by beneficiary designation, naming the beneficiaries, signing the document, and they pass accordingly. Those are also pretty easy designations to update as we work with either the manager of our retirement accounts or our life insurance agent. The last will and testament, for me, I always talk about this as being like a catch-all or a funnel to capture assets that have not otherwise been targeted or tagged, and a legal path created. And so we'll talk about that a little bit here. So let's talk about a will. Remember our slide early in the presentation where we saw that perhaps 50% or maybe even 60% of the population doesn't have a will. Well, if you don't have a will, the state has one for you. If you don't have a will, you would fall under what we would call the intestacy code. And the state has kind of mapped out a predetermined plan for where the assets would pass. To be fair, the state tries to pass it on in a way that would move it to your closest living relatives, those closest to you in the family. And also, to be fair, sometimes worry about, well, if I don't have a will, they'll tax me much more heavily. That's really not the case. There's no further taxation if you don't have a will, but your estate certainly could be tied up in the probate process, in probate court, for a longer period of time. So let's talk about some key components of a will. You know, what's in it? Well, the first thing, here's this fancy word, exordium clause. That's really kind of the intro to the will. It's a little bit of a personal summary. That's all that word means. And then the will goes on to identify the important people in your life, the heirs to whom you would want to share your estate assets. Sometimes there are specific bequests of certain assets to certain persons. There are residuary bequests, you know, of all of these assets, I want them to be divided equally between these persons. Sometimes there are contingent bequests, which is if this happens, then I want this to happen. If these people are no longer living, I want this to happen. And of course, one of the key components of a will is selecting the person who you would want to settle your estate, known as the executor, or in some cases, that person is known as the personal representative. So those are some of the key components of a will. Talk about probate a little bit. What is probate? Well, probate is really a court process. It's when a person passes away, their will, which has not been entered into the public record previously, is entered into a court proceeding overseen by a judge. And the purpose of probate is to prove heirship, to make sure that the assets go where the decedent intended them to go, and then to be involved in overseeing the changing of legal title, so everything is done according to good order. And so the wishes, again, of the person who's passed away are followed. It takes some time. There are some fees related to probate, but that's the purpose of probate. So let me ask you this question. If I have a will, would my estate avoid probate? What do you think? I can't hear you, so I'll have to answer the question on all of our behalves. The answer is no. Our estate does not avoid probate if we have a will. In fact, a will always is required to go through probate. However, there are some means of passing on assets that avoid probate. One of those would be gifting assets, and gifting implies gifting them during our lifetime prior to our death. Assets that pass through beneficiary designation, again, like retirement accounts, life insurance, those avoid probate. The legal path is created, and so it doesn't need to go through probate court. There are sometimes payable on death accounts, transfer on death accounts for things like bank accounts or perhaps investment accounts. Joint tenancy is a form of owning property together with another person that avoids probate. The legal path is created. And then there are living trusts. Trusts avoid probate because trusts are admitted to the court and proven ahead of time, not only at the passing of the decedent. So let's talk about joint tenancy here a little bit. Very, very common to estates is to hold assets in joint tenancy with spouse, meaning that an asset such as a home or other assets are owned jointly together. And when one tenant passes, those assets go directly to the other person. That's all good and fine from one spouse to the surviving spouse. But upon the second death of the surviving spouse, those assets still must go to probate unless they've been gifted or directed in another way. If there are assets that are owned in common in joint tenancy, if there's a common accident, there's no time for planning what to do beyond the survivor. And the other thing is the limitation of joint tenancy. Planning in some cases might be necessary during a time of grief for the surviving spouse. And under certain circumstances, and I would say this is especially with larger estates, there's some potential loss of tax benefits if all assets are passed to the surviving spouse. I'll say this, there is something known as unlimited marital deduction. So there's an unlimited amount of assets that may be passed to a survivor without a taxed event. However, there are limitations on what a survivor can pass on to heirs. And so that's why some pre-planning, sometimes it's not always the best idea to pass everything to the survivor, but rather to make some other provisions. That's something we talk about in our planning process. Joint tenancy with children. Some people think, maybe this is the issue. Let's just set up joint tenancy with our kids. And in some situations, this is fine, but there is a certain loss of control on the part of parents if we own assets together with our children, because if it's joint and something happens to us, it all goes to our children. But the other thing is, if it's a joint tenancy, the child may be able to make full decisions even while we're still living. So, and then the property could be exposed to debts of our children. And again, another situation here where there may be some potential loss of tax benefits. Moving forward, we'll try to speed up here a little bit more. Let's talk about trust a little bit. This thing called a revocable living trust. Sometimes persons have a very brief, like 2-page, what they call pour over will, to pour any assets that aren't already guided by the trust into a trust at their death. A revocable living trust, what does it do? Well, let's talk about it. Revocable, that word means that it is changeable, as is a will. These are not documents that are written in concrete or in stone. They are always changeable if they're written to be changeable. So a living trust is a changeable, revocable document. It doesn't offer the same creditor protection that an unchangeable will would offer. Living means it's created during life, and there are 3 basic legal parties to a living trust. There's the grantor, the person who really owns the assets initially. There may be a trustee who could be the grantor initially, but then pass on to someone else. That's the person who oversees, manages the assets. And then there's the beneficiary. That's the ultimate beneficiary, the destination of those assets. Okay, here's a picture of a trust. How often have you seen a trust pictured? It's kind of like a Loch Ness monster, you know. It's very rare to capture a photo of a trust, but this is what one looks like. And you can see here are the primary players. You can see a grantor there at the top. Isn't that kind of neat? Here he is pouring the assets into the trust. The grantor funds the trust. The trust then does its thing. That's, you know, it makes investments, it generates income. Well, first let me say the trustee manages the trust. That can be the grantor initially, but then maybe someone else. The trustee manages what's going on in the trust. You can see the principal. There's one little drop coming out. Hardly any principal comes out. The trust is really about generating income for a period of years, a term of years, to income beneficiaries along the way. And then ultimately, down the line at some point, are the remainder beneficiaries who will ultimately end up with the assets that have been held in trust. So there's a little bit of a picture of how a trust operates. A living trust is one of those entities, one of those planning tools that skips probate. It's a legally approved document, so the grantor funds the revocable trust. The grantor, as I said, can be the trustee initially. At the grantor's death or disability, there's a successor trustee. And then at the grantor's death, those assets pass on to the ultimate beneficiaries that have been named in the trust. Funding a trust is a must. Occasionally I work with people who have had a trust drafted by their attorney, and so all's in good order except the trust isn't funded, and which means it doesn't do any good. And so if you put together a trust, be sure to fund the trust. But these are examples of some of the kinds of assets that often go into trusts for the benefits that a trust offers: real estate, bank accounts, stocks, bonds, insurance proceeds. You'll notice not very often, very rarely, in fact, would anything like retirement assets go into, certainly not go into a living trust. Fitting the pieces together, here we have a little diagram about how all of that works during life and at death. And I'll just kind of keep moving ahead here today. So moving on to the next level then, some basic estate planning. There's something called a credit shelter trust, known also sometimes as a bypass trust or an AB trust. A credit shelter trust is a planning technique for larger estates, really only necessary in larger estates, where the total assets owned by a couple would be above the level of the federal exclusion. And in that case, not all assets pass to the surviving spouse. Some go into this credit shelter trust using the exemption available to the first spouse who's passed away, preserving the exemption for the surviving spouse. So it's a way for increased tax savings. Sometimes persons who have large life insurance holdings and on top of a large estate, since life insurance counts towards whether an estate is taxable, a common technique would be to move life insurance proceeds into a life insurance trust that moves it out of the taxable estate. So that's what we're talking about here. Okay, let's talk about this. Whether you knew it or not, you have two estates. It's not just one estate, but it's two estates. The gross estate is the total estate for federal estate tax purposes. It's everything encircled here in blue. It's taxable in a federal way, but maybe not subject to probate. The probate estate are those assets that are specifically required to go through the probate court for the proving, for the distribution. So things like personal assets that are directed by the will, stocks and bonds, real estate, business interests are probate assets. Those other assets like life insurance, joint property, retirement accounts, revocable trusts, of course, avoid probate. Finally, top of the building here, advanced planning tools. I rarely get into this territory with most of my planning clients, although those with large estates, this can be tremendously powerful as planning techniques with them. But the acronyms here stand for grantor retained annuity trusts, qualified personal residence trusts. Both of those are asset freezing techniques that would serve to limit the potential federal estate tax due to that estate. Charitable remainder trusts, charitable lead trusts, basic bequests of assets, many planning tools. As I work with planning clients, our goal is always to tailor the tools to the situation of the planning clients. Okay, so let's talk specifically about this Thompson and Associates planning opportunity that is available to you through Jamestown Regional Medical Center Foundation. This is a service provided at no cost to you. That's because JRMC pays an annual fee to Thompson and Associates. The fee is based on only one thing, and that's how much time am I on site or working with Jamestown people every month. I don't get paid more if I see more people or less if I see fewer planning clients. And I'm certainly not incentivized or motivated, compensated in a commissioning way to make any outcomes happen. That would not be ethical. And so no cost to you as a planning client. What we do, we provide estate plan review, education, advice. We don't have any products to sell. We don't sell insurance or manage money or sell annuities or anything like that. Everything we do with our planning clients is held in strict confidentiality. I don't share with Lisa where people begin their plan or where they end their plan, or certainly what we're talking about in our meetings. It's full confidentiality, and our services are provided without any obligation. This is truly a planning process. This is not a solicitation for a charitable gift. It's a values-based process. If people have an interest in doing something beyond their family for charities, we can absolutely help you to do that and to find the very best assets to use. But there's no expectation or obligation that charity will be part of your plan. Okay, quickly, our planning process begins like this. Here's the main question of estate planning. In fact, do we have enough to live on for the rest of our life? We respect that fully. That is the core of planning for every person or every couple. Question 2 in estate planning: how much should we leave to our heirs? And it's really not only how much we should leave to our heirs, but how do we leave it to them in a way that is good for them? I think we can all agree that too much too soon is not necessarily a good outcome for heirs. And heirs vary in their abilities to manage wealth. So we need to do planning in a way that addresses the uniqueness of your family members. The third primary question of estate planning is what I call the social capital question. It's what should I do with what's left? Or what should I do with that either must go beyond the family to tax, or we might want to go to charities through gifting to charities. Either way, we're talking tax or charity serving societal needs. But there's a unique opportunity in estate planning, and that would be to redirect dollars that otherwise might go to tax to charity. And I find that many, many planning clients have an interest in how do they make that happen? Is that really possible? It is. Our planning process as we work with people begins with talking about values. We have a values-based questionnaire, 23 questions. I send it home with each spouse to begin the process, ask them to go their own corner, no copying off the other person's paper, but think through these questions of estate planning. And then they bring the questionnaire back as they meet with me in the second meeting. I facilitate a discussion of their responses, and we probe areas of agreement and areas of, let's just say, different perspectives. That's where we begin with the questionnaire. We summarize answers to the questionnaire in a document that we call the Statement of Values and Objectives. After the couple has completed the questionnaire, one of the members of our Thompson team puts together this 2-page summary of what has been important to them in the questionnaire. We, of course, need to take a look at net worth information, get our arms around taxable assets. And so we ask all of our planning clients to complete a net worth statement, which again, of course, is held in absolute confidentiality. We produce a comparison spreadsheet. Here's the current plan. Here's a recommended plan. We work through several editions of this, several increments, until the planning client comes to a point where they're saying, you know, that makes sense, and I like that, and yeah, that would make my plan better. I meet with people normally between 4 and 8 sessions, whatever it takes. In fact, whatever it takes. One time I had a guy who met with me 22 times, but usually 4 to 8 will do it to get people to a point where they've been able to review their plan, receive some education, explore possibilities, and own the outcomes that we arrive at together. So if you are interested in meeting with me as I work with Jamestown Regional Medical Center friends, contact Lisa, and she can help set up a meeting with me to get us started. Even if you'd like to come in once and ask a question or two, or check me out, check out this process further, please contact Lisa. There's no obligation. You only move ahead if you're interested in moving ahead, but I think we can help you. So, brings us to questions, and Lisa, I'll toss it back to you and out to our audience and see if anyone has any questions that we can help with today. Thanks so much for your attention, and I hope this has been useful to you.
Thanks so much, Doug. We really appreciate your time and your depth of knowledge of this resource. You know, when I started out just even in philanthropy, learning about how a great plan can articulate people's wishes and grow a family together, and to see them accomplish some goals where, you know, you didn't even know that that type of opportunity existed. To not avoid the process is a beautiful thing, because it can create some great family harmony, as well as do things that weren't always maybe an option in the community. So I thank you for your time. We will sign off. We will sign off here, and have a great rest of the week. Thank you so much.
Okay. Thank you all. All the best.